Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the recent judgment by the Supreme Court quashing government tax demand of over 11,000 crores on Vodafone. The Supreme Court also suggested to the government that it may consider legislation to remove the gap that exists in the legal framework. The proposed direct tax code bill specifically provides for the imposition of capital gains tax on overseas acquisitions if the acquired company holds over 50% assets in India. But the bill is yet to become an act. To discuss the issue, I have with me Mr. Asim Chawla, partner Amar Chand and Mangal Das and Suresh Shroff and Company, and Mr. Rupesh Jain, partner Vash Associates. Now for the headlines. Deals between two foreign entities can't be taxed even if the companies have assets in India, rules the Supreme Court. But this will hold true only if it is evident that the deal has not been done with the intention of evading Indian taxes. The direct tax code already has a provision which enables the government to impose capital gains tax on overseas acquisition, but the bill is yet to be passed by the Parliament. Indian authorities will not have jurisdiction to tax any deal which is made between two foreign companies, even if the company in question has assets in India. But this exception will lie only if the deal has not been done to avoid Indian taxes. The Supreme Court has held that the deal between Vodafone and Hutch SR, two foreign companies, did not take place to avoid Indian taxes and struck down the tax department's claim of over 11,000 crores.
The Supreme Court judgment is likely to benefit several foreign companies who are fighting similar cases against the tax department. Some companies like AB Miller's buyout of Foster, Sanofi Aventis acquisition of Shanta Biotech, Kraft Food purchase of Cadbury, and Vedanta's takeover of Kane India all stand to benefit out of decision.
The Supreme Court has done a wonderful job in highlighting the necessity, the commercial and the economic necessities of having such structures in place, and emphatically stating that having such legitimate structures will not in any way be regarded as a device for avoidance of taxation.
Let's look at how the entire story unfolded. In May 2007, Vodafone bought Hutchison Telecommunication International Limited 66.98% stake in Indian telecom company Hutch SR Limited for over 52,000 crore rupees. Hutchison controlled its Indian telecom subsidiary through a Cayman Island company called CGP. CGP shares were sold to Vodafone, which consequently became majority owner of the Indian telecom firm. Indian tax authorities alleged that the transaction amounted to indirect transfer of shares NSS in India and hence should be subjected to tax in India. But Vodafone had consistently maintained against the tax claim on the grounds that the 2007 deal was between two overseas companies. The dispute landed in the Bombay High Court. The High Court directed Vodafone to pay a tax of 11,218 crore rupees for acquiring the operations of Hutch SR. Vodafone appealed to the Supreme Court after losing the case, and now Vodafone was granted relief.
Basically, here we are dealing with shares. Shares are capital assets. For capital assets held by non-residents, the rule is that the location of the capital asset is important under section 9, and if the location of the capital asset is outside India, then the tax is not payable in India. So to that extent the judgment is absolutely correct, because it looks at the provision and reads it strictly and comes to the conclusion that the tax is not payable in India.
The verdict was delivered by a three-judge bench headed by Chief Justice S.H. Kapadia, Justice Swatantra Kumar and Justice K.S. Radhakrishnan. The majority judgment was delivered by Chief Justice S.H. Kapadia. The Supreme Court verdict on Vodafone tax case is not only a positive signal for the foreign investors who are investing into India, but also a victory for Vodafone. With camera person Gajendra, Aruna Thakur, Rajya Sabha TV.
There are similar transactions that have similar legal tangles that need to be sorted out. There is AB Miller's buyout of Foster's, Sanofi Aventis has acquired Shanta Biotech, Kraft Food has purchased Cadbury's, and Vedanta's takeover of Kane India will stand to benefit out of this decision if the government doesn't interfere. Asim, what is the implication on these cases?
Well, gives a good head start. At least all these cases and all these ensuing legal controversies and battles will have some head start, some room, some takeaway platform to move forward. I think a lot of groundwork has been done. This is a very elaborate judgment. In fact, we have two judgments, one a majority judgment and a concurring judgment. So looking at the way the Honorable Supreme Court has propounded certain principles in terms of suggesting when a transaction may fall within the four corners of law, you have to look at the historical perspective. There are 6 or 7 touchstones which Supreme Court has laid down, and I'm sure all the ensuing legal controversies would find favor from various tests, various propositions, various findings which the Supreme Court
has already come
given.
to.
Yeah.
What is the gap? The gap was location of capital assets here, there, to be taxed or not to be taxed. Now this gap was existing and the Supreme Court found this gap and interpreted it in a certain manner.
Right.
How can it be prevented? What does the government do as of now? Because there are several other tax implications. Revenue for the government is a huge, huge thing, especially for a developing country like India, because there's a lot that has to be spent all across. Development has to take place. And if these setbacks continue, it's not really proper for a developing country like ours. So what do you think, how should it go to the next level where the other lined up cases
Right.
don't go the same way as Vodafone did?
All right. You see, first we have to understand that you have to look at the law as it is. Now, what the revenue had wanted to do was to put a spin, so to speak, on the interpretation of the section, and they wanted to give it a purposive interpretation, which the Supreme Court said cannot be done, where it alters the basic character of the section or the charging provision. So the opening lines of section 9(1), which says where there is income directly or indirectly through certain things, and including through the transfer of a capital asset situated in India, then that income would be deemed to accrue or arise in India. Now the department wanting to say that if there is even indirect transfer of asset in India, even then the provision applies, which the Supreme Court says is not the case.
Yeah.
And you see, this is how the provision has been interpreted over the years, not only by the taxpayers, but also by the government. So you can't wake up one day to say, no, this has totally entirely different meaning. When the investment was put into India, it was under the impression that the law is this, and this is how it is going to be interpreted.
Yeah.
And so now, if you want to change the law, of course, it is your prerogative to change it. Legislature can always do it, but do it prospectively. So if we have the budget coming up, if the government wants that indirect transfer of assets should also be taxed, then what they need to do is amend the law, and amend the law prospectively, so that the foreign investor is aware that what would be the tax exposure in India if he were to invest in India.
Coming to you, Asim, what is the novelty of this entire judgment? It's a very well-written judgment, interpretation, after a lot of discussion and arguments and all top lawyers participating in the process. The net takeaway, which is the novelty of this judgment, 11,000 crore rupees adds the glamour aspect, the big, show bit. But what is the legal takeaway and the final novelty of this judgment?
I guess several. I mean, having gone through for last 4 years, navigating the whole legal pursuit of Vodafone, first and foremost is the fact that in the span of 4 years, this matter came to Supreme Court twice. And the Bombay High Court adjudicated upon the matter twice. Let me sort of step back for a moment. When the matter first came before Bombay High Court a couple of years back, the Bombay High Court did rule in the favor of tax department. And the matter was taken to Supreme Court. And Supreme Court said, first and foremost, you decide whether Indian tax authorities do have a jurisdiction to look into such a transaction which prima facie involves only non-resident. There is a non-resident buyer, there is a non-resident seller. The subject matter of shares are of a foreign company. So how come Indian revenue authorities do have a valid jurisdiction? And therefore, with these observations, the matter was remanded back to the tax authorities to first and foremost decide whether they have jurisdiction or not. The tax authorities passed an order on jurisdiction, which was challenged before Bombay High Court, which was the impugned order before Supreme Court. The Bombay High Court said that, well, there is some nexus with India. What is that nexus? The assessing officer can do that fact-finding authority. We believe there is something, and therefore on our prima facie belief, there is a nexus. And then the matter came to Supreme Court, which is the instant judgment what we have. Now,
Exactly.
Now let us look.
It's time for us to head into a break. When we come back, we will come back. We will talk about how the enactment of the direct tax code could have prevented this setback to the government. And also we will talk about what Asim is trying to make a point. Yeah. Welcome back. The judgment favoring Vodafone came as a shock to the government. The downside is that the judgment sets precedents. With the help of this judgment, there are several foreign companies who could get away without paying taxes on the ground that they are foreign companies acquiring Indian companies through an indirect route.
There is a feeling in the government that the review of the judgment may not be practical because the Apex Code had already discussed the issue thoroughly. But if the government does not plug the policy gap, it stands to lose huge revenue, which is crucial to growth. The option that the government may exercise is to ensure a passage for the proposed Direct Taxes Code Bill in the Parliament. The bill specifically provides for the imposition of capital gains tax on overseas acquisitions if the acquired company holds over 50% assets in India.
In fact, the Supreme Court ruling itself makes a mention of the direct tax code and goes on to say that because direct tax code contains such a provision, and in fact by way of an exemption for such a transfer, it implies that the current law does not have that provision, and therefore we should not try and read that provision into the current law. Now, in future, obviously the government has shown its intent to bring in specifically the provision relating to indirect transfer of assets. Also, the government proposes to bring in general anti-avoidance regulations, in which case the commissioner will have the powers to disregard a transaction if it lacks commercial substance.
The judgment clearly states that the investment structure had to be respected, and it was to be determined whether an investment was made for participation in the entity or whether it was preordained transaction aimed at avoidance of taxes. In this case, the Apex Court felt there was no attempt to avoid tax. The minority judgment by Justice K.S. Radhakrishnan suggests that effective legislative steps need to be taken to ensure that passing of inconsistent orders by courts, tribunals and other forums putting revenue and taxpayers at bay can be avoided in the future.
Radhakrishnan's judgment has been concurring judgment, so it is not that he has deferred either on merits or on arguments. He has chose to write a separate judgment. Only one or two things which stand out in his judgment which do not find a mention in the majority judgment. One of which is that he has observed that section 195, which deals with taxation of withholding tax on payments to non-residents, does not apply to non-residents. This view has been taken for the first time specifically by the Supreme Court, and we will have to see how far this will have an application. But other than that, I would imagine that Justice Radhakrishnan's judgment is a concurring judgment and there is no difference.
The Apex Code also said that the insufficient legislation may allow an opportunity for money laundering and tax evasion. So it is the duty of the Parliament to address such issues with utmost urgency. The Vodafone tax case clearly stands out that there is no tax on indirect transfers, but can be possible by bringing a new law by the Parliament. With camera person Gajendra, Aruna Thakur, Rajya Sabha TV.
It was the gap in the legal framework that favored Vodafone, and that is exactly what is highlighted by the minority judgment. To you, Rupesh, 195 non-resident, the aspect brought out in the minority judgment.
Right.
The implication of it, application of it, if any, or should we just ignore it?
You see, the majority judgment does not go as far as Justice Radhakrishnan does. Though majority judgment also says that the transaction has to be chargeable to tax in India in the first place. And secondly, they also hint at some kind of a taxable presence of the person who is paying the amount on which tax is to be withheld in India. So in a situation where the foreign payer has no tax presence in India, whether you can still apply section 195, which is a procedural section, is a moot point. And maybe the decision of Supreme Court, the majority judgment I'm talking about, not Justice Radhakrishnan's concurring judgment, can be said to be read in this manner that there has to be some kind of a taxable presence of the foreign payer in India. And that presence has to be seen vis-a-vis the relevant transaction, not that the foreign payer is present in India for some other purposes, and you say since he is present in India, therefore even in respect of the transaction which he has entered into, which has nothing got to do with his presence otherwise in India, he is subject to section 195. So some kind of territorial nexus of the foreign taxpayer or the foreign payer of income with India is required in order to apply the tax withholding provisions.
Right. The application of it, the minority judgment.
Yes.
What will be the application? Will it at all be able to be applicable or not?
I would think that it may not have a precedentiary value for the reason that the majority does not say that they concur with the decision of Justice Radhakrishnan.
Right.
In McDowell's case, in fact, the majority did say that we concur with the decision of Justice Chinnappa Reddy,
Right.
Wherein he had made some observations. Of course, now the Supreme Court in this Vodafone case has said that you have to read Chinnappa Reddy's observations only in relation to colorable devices,
Right.
and not whatever he has said, because majority concurred only with that part of the judgment and not the entire judgment.
So that is why the application will not be as wide.
Absolutely. So it will be suspect, the precedentiary value, because the arbiter dicta of the Supreme Court is also binding.
Right.
But whether the concurring judgment of the single judge, Justice Radhakrishnan, would even have the effect of arbiter dicta, to my mind, is extremely doubtful.
Right. Asim, the point that you were making in the earlier part, the takeaway, the important takeaways, and what one can actually apply as long as there is a gap in the legal framework.
Well, considerable emphasis has been placed on the factum that what is a strategic foreign direct investment. And if a foreign direct investment can qualify the tests of bona fide, in other words, there is a intent to participate, the duration of time for which you've made that particular investment, period of business operations in India, how much amount of taxable revenues you've generated, continuity of business, timing of exit. So that's one very important takeaway, because a considerable influence or an emphasis has been placed on the fact that this was a case of a genuine strategic foreign direct investment. That is one. That is why people believe, or that the general consensus or a large emerging view is that it's a very pragmatic judgment, looking at the contemporary flows and the contemporary business underlying situation in India. Not in very recent pasts, the courts have gone into the levels of sophistication in understanding the transactional documentation, understanding these very, very innovative, sophisticated corporate ways of doing cross-border transaction. That's one piece of it. The other important piece of it is the knocking of the door and suggesting to the Parliament that perhaps there is a gap. Please look at it. You have the supreme prerogative of altering, amending the law. If you believe in your wisdom that this requires an amendment in law to plug the gap as you are referring to, you may consider it. They have not lost sight of Direct Access Code, which proposes to plug that gap with
Yeah.
regard to indirect transfers. The courts have also taken a very holistic view that what has been transferred is transfer of shares and not transfer of asset.
Right.
And therefore, a holistic approach has to be adopted in looking the transaction as a whole. We can always argue the fine line of difference between tax evasion and tax avoidance. And the cattles can go home in terms of that argument that what is avoidance and what is evasion. But again, they have gone back, as Rupesh mentioned, they've looked at the earlier pronouncements, they've looked at McDowell, they've looked at Azadi Bachao Andolan. The doubts on Azadi Bachao Andolan have been put to rest. The third important aspect which comes from this particular judgment, apart from the issues of evasion and avoidance and apart from aspect of Section 9, is a little doubt on the obligations of withholding taxes, which we all understand that to an extent it might not catch the imagination unless and until the legislature decides to clarify it. And the opportunity is very well timed. The finance
session
bill is round
yeah.
the corner, and this might be a good provocation for certain amendments which may
To
be
come and
viewed
take place.
very, very seriously.
On that note, it's time for us to head into a break. When we come back, we will show you an interview with R.S. Ahuja, who is a fellow chartered accountant. Welcome back. My colleague Aruna Thakur spoke to Mr. R.S. Ahuja, fellow chartered accountant, and tried to get an accountant's perspective into the whole matter.
So what is the Vodafone case is all about?
See, Vodafone tax case involves the transfer of shares of a Cayman Island company. That means it is the sale of shares by one non-resident to another non-resident outside India, the result of which was that underlying shares of a company in India changed hands, which resulted in capital gains arising in India.
So why the Vodafone tax case transaction is not applicable on the Section 911 of the Income Tax Act?
911 is a deeming section. Now here they talked in this case of a principle called look-through. So here what they have held, they said look through because of the use of the words through and indirect tax, indirect transfer in the Section 911. And since it's a deeming fiction, the Honorable Supreme Court held that a deeming fiction cannot travel beyond a point to decide this case to say that the transfer of shares in Cayman Islands, in the Cayman Island company, would result in the indirect transfer of assets in India and therefore become taxable in India.
So there are certain principles have been laid down in this judgment, like looked at versus looked through, tax avoidance and tax evasion. Can you please briefly tell about these principles?
Look at principle is a principle which the Supreme Court has enunciated, where they have said that you look at a transaction in a holistic manner, that means in a complete manner. Do not bisect the transaction or dissect the transaction into various facets and take one piece at a time. So this is the principle that has been, look at. The other thing they have said is regarding the subsidiary company, because all these companies which are formed outside for investment purposes into various countries, they are always a very complex system of shareholding between one company and the other, and there is parent, subsidiary and subsidiaries. So there they have said that subsidiary companies and this complex way of holding shares is a reality, and unless the income tax department, the revenue, is able to prove that they are a sham or they have been created to evade tax, then other than that they should be treated as genuine.
So as an expert on this subject, how do you see this judgment?
This judgment is a great development in our law. The judges have gone out and studied almost all the international judgments that were available on similar kind of cases, and it's a very stable judgment.
According to Mr. Ahuja, the judgment is a sound judgment and has been delivered after serious deliberations. Rupesh, the macro view, why FDI, holding structure, all that. What has the court?
Yeah, see, the Supreme Court looked at a macro perspective, and they said that why you require these holding structures are because in India there are several regulatory approvals you have to take if you were to come directly, and you have to provide an exit route to the investor, and that is why these structures are put into place. Now, that gives a business or a commercial rationale for these structures. So, tax avoidance is not the purpose, so to speak, of coming through Mauritius. There is a business or commercial rationale to it,
Right.
which the Supreme Court looked at, and they said that you have to look at things or subject matter from a commercial and realistic perspective, and not entirely technically or in a legal manner. So, which to my mind is a very key
Innovative.
factor. Yeah, key factor which has determined the outcome of this decision.
Right.
That is one. And secondly, the robustness of the Indian judiciary because of this decision, that they've been able to look through the transaction as such, and also the interpretation which the department wanted to give to a particular provision, which they thought is not the correct interpretation. Yeah.
Coming to you, Asim, you were talking about DTC, then the anti-avoidance and the Indian-Mauritian Treaty. What implication?
Very quickly, I mean, Direct Access Court believes that the presumption or the onus is on the taxpayer to prove that whatever he is doing correctly to begin with. Whereas the judgment says that the onus or the burden is on the revenue to prove that whatever he is doing wrongly. So DTC and this particular judgment are a little poles apart, but then DTC is a legislative intent. If that were to come through, then you may find the principles on that aspect may get usurped or diluted. As far as Indo-Mauritian tax treaty is concerned, Justice Radhakrishnan judgment makes certain observation with regard to the conclusiveness of the very contentious tax residency eligibility to claim tax treaty benefits, etc. Well, whether those observations are concurring with the majority view, since the majority judgment doesn't make any expressions on Indo-Mauritian tax treaty, and technically the subject matter was not Indo-Mauritian tax treaty, one may tend to take a cue that this is what the general larger thought process of judiciary is. So one really cannot ignore. But having said that, treaty is there in place, stays, unless both the parties to the treaty, two sovereigns, decide to alter it.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.